Welcome to episode 3, Your Cup of Counsel, Legal Talk Served Hot. Today, we are diving into whether or not the rumors are true, answering top 5 questions we have heard from either clients or friends and family members, and we're drinking Phil's. Started right here in San Francisco, one of our favorites. Don't forget to like, subscribe, leave comments. Today, we're going to be answering questions about whether or not the rumors are true. We're going to do a true and false Q&A, answering 5 questions that have either come up by other clients or come up at cocktail parties that we think our listeners may enjoy hearing.
Yeah, I'm looking forward to it. I also noticed that it sounds like we go to a lot of cocktail parties because a lot of our questions we explain as having come from cocktail parties. We're not that fabulous, actually. We don't go to that many cocktail parties, but we do go to places where people ask us questions. And I know for me, I'll get into an Uber or a Lyft and I'll make the mistake of telling the driver that I do this job and that I'm an employment attorney and I do race discrimination and sex harassment cases. And inevitably, there are basic questions that get asked of me that spawn really interesting conversations. And some of them are totally true and some of them are totally false. So that's the point of what we're doing today, is to either debunk or solidify some of the things that we've heard and tell you whether the rumors that you also might have heard are true.
Great. So I'll start off with the first question, which is, are women paid less?
Yes. So again, with most things in the law, it depends. And obviously not all workplaces pay women less. So this is not an across the board thing. But there are certain markers and certain events in a woman's life that can cause over time them to be paid less. And I should also say there are actually hard statistics on this. So there's, I believe, census data, but other pay scale data that actually supports this, that I think nowadays, women are paid, I want to say 80 cents to the man's dollar. Don't quote me on that, but it used to be 75 and I think it's gone up a bit. But there's, so what I'm saying is just my own observations from what I've seen in my cases and from talking to other women and talking to other lawyers and seeing actual pay records and seeing a lot of them and being able to compare them with what men are making at the same company. But my observations, it turns out, are also backed up by actual statistics, unfortunately. So I think, sometimes it can be women who take time off to have children, right? And if there's a big lapse, whether it's some women decide to take a lot longer than they're entitled to, if they take a full year, for example, or even less than that, what we see statistically is that can put a bit of a bump in their career trajectory, unfortunately. And if they're not working for a place that really honors and values working mothers, then that can have a spillover effect to when they return to work, which means they aren't able to work the same hours, or if they aren't in a workplace that has flexibility, then that can really impact the shifts they're allowed to take and their upward mobility. There are various dynamics in the workplace that also lend themselves to this. Like if you're in a workplace that's run by men who have never had to raise children, or by men who it's been a long time since they've raised children and they don't necessarily immediately relate to the struggle of raising children, or of relating to women in general, then that can be another piece that sort of pushes women down a little bit. So it's not so much that it's a workplace that is intent on paying women less. It's that there's these various, we call them systemic things, right? That all kind of work against women in the workplace. That's not to say there aren't women thriving and succeeding and kicking butt and doing all the things and making all the money. There certainly is, but particularly in lower, more entry-level positions, we see it a lot more, but even also all the way up to the executive side of things. And I've done a ton of pay equity and gender discrimination cases for C-suite executives that absolutely should have been paid the same as their male counterparts and just weren't. And, there's sometimes good reasons for that, but a lot of times there aren't really good reasons. It's just something that the people at the company haven't paid attention to. And that's obviously where I come in.
Yeah. I've had friends ask me, in a year where they've had a child and they've taken 4 months or 6 months off, and they're coming to the end of the year and they're back at work and they're afraid that their bonus is going to be reflective of the time off. Not to get down a legal rabbit hole, but how does that work? Can an employer pay you less because you took time for maternity?
So it really depends on whether your bonus is discretionary or not. Theoretically, yes, an employer can pay you less if the bonus is discretionary because they can look at your quote unquote work output over that year and make decisions based on that. However, if you ever get the sense that your compensation is being minimized because you went on pregnancy leave, which I know it sounds like maybe a distinction without a difference, but it really is an important distinction. If you're being punished or your compensation is less or you're getting less work opportunities because you went on leave, that would be an illegal act. We call that an adverse employment action. So it's really fact specific. It depends on the type of bonus. It depends on the type of leave that you took too. That can make a distinction. Depends on what your workplace policies are for maternity leave, which sort of overlays whatever the legal framework is. So that's a great example of something you need to talk to your lawyer about. But the general, my general view of that is, if you think you're being punished in any way for taking maternity leave, that is protected medical leave. So you have the right to take that leave, and you have the right to have your same job when you get back. And if there's ever any question about that, or if you think you're being paid less because of your pregnancy, then you probably have a claim you should talk to a lawyer about.
Are there any resources that people can go to? Like, I'm in a job, I have a suspicion that all the men at my level are making more. Do employers have to publish that data? Is it okay for coworkers to talk to each other about pay? What do you recommend people do?
Great question. It is absolutely great and should happen that you talk to your coworkers about pay. And in fact, if you ever believe that you're being either retaliated against, or if your company's saying, don't tell anybody what your bonus is, or I've seen letters where it's, your bonus is between you and the company and you need to keep it confidential, you are absolutely allowed to talk to anyone you want. And I actually really encourage that. I think women in our society in general don't talk about money enough. I mean, people in general don't, but I just find particularly with women, we're very careful. We're so concerned about relationships with each other that we don't ever want to come across as cocky, or maybe it's a competitive thing and you don't want to be the one that's paid less than your friends or whatever it is, but we don't talk about compensation enough. And I think that really operates to push people down. So talk about it with your coworkers. You're also absolutely entitled to ask HR, am I being paid the same as people that are on the same level as me? There are rules around what HR can share about other people's pay information, and they may not share specifics with you. But if you raise, and I always also suggest raising things in writing by email, if you can do it in a way that doesn't make you look like you're trying to prepare for a lawsuit, hopefully, but raise it in email and ask, I think that I'm of the same seniority level and have the same experience as my male counterpart down the hall, and I'd really like to know that we're being paid equally. And it may be that your HR person is really well-intending and just didn't even think that should be equalized, and it may cause them to look into it and say, you're absolutely right. The way that we look at this in the law is they look at various factors like your seniority level, your experience level compared to that male counterpart, your general responsibilities and job title, and the function of your job currently, and those types of things to decide whether you're the right comparator. So I say that because sometimes people think, well, Joe down the hall is making more than me, but if he has more education than you do or worked at a higher level before coming to the job, there may be reasons that are totally justifiable that he's being paid more, and gender may not be the motivating factor.
Yeah, that makes sense. Okay. All right, let's go to our second question. Do insurance companies nickel and dime every claim?
This is a question for you more than for me. Insurance in the employment is not as prevalent, it is not as actively litigated, or it's not as big of an issue. So tell us how insurance companies behave on your cases.
Okay. The trend has been very poorly recently, which is such a bummer. Insurance companies are nickeling and diming everything. They're reaching out to victims the same day, the next day, within 3 days after an accident, saying, have you been hurt? What are your bills? Send us your bills. We'll send you a check, because they're trying to give them, quick, low value hush money, essentially. Sign a waiver. Here's a check for $2,500. You'll be better in a week. Well, we just want to make sure that you're taken care of. So here's your check now. And they're having people sign away their rights, which is really sad. And I always tell people, never be in a hurry to settle your claim, especially if it's something that's just happened. You don't know how you're going to fare. You don't know how treatment's going to go. And so don't fall victim into that kind of insurance scam.
Right. I mean, that's wild because a lot of your injuries, people, I mean, I've been in, really minor fender benders and things. And even just with a bit of whiplash, like you get into the accident and you're like, okay, you're walking away, you're fine. And then the next couple days are brutal. So I could imagine like you may not know what medical treatment you even need at that point in time.
Yeah. The other thing that I think a lot of people don't know is that there can be medical negligence that happens. So say you have a broken arm, break your arm, requires surgery, surgery seemingly goes fine. You think that you're on the mend. You may rush and settle your case in like the first 2 months. 3 months out, you get a horrible infection. Then you're going back, you need another surgery. Something goes wrong on that surgery, and then you need a fourth surgery. I mean, it can spiral out of control, and I don't want to paint like doomsday scenario, but if you've settled the case too early on, then you're not aware of all of kind of that cascading that can happen on the back end, which insurance companies know. And they know that people are excited to settle a case without getting a lawyer, without having to pay a lawyer a share of the settlement.
Mhm.
And so they rush these quick, low-value settlements. So I always tell people, listen, if they've offered you $2,500 today, it's going to be on the table in a week, in 2 months. They want the case to go away. The insurance company does. If their driver or company was at fault, they want the case to be resolved. They're not going to take that money off the table.
Yeah, it's so interesting. That's actually, there's a similarity with employment cases because a lot of times what will happen is an employee will go through like horrendous mistreatment and the company will say to them, they'll come up with performance issues, right? So they'll say, by the way, we have all these complaints about your performance and now we think we want to fire you. So we're going to fire you, but we'll pay you a severance. But in order for you to get the severance pay, you have to sign this form that is releasing all of your legal claims, right? So the person is thinking, well, if I choose the severance pay and take the money, that means I get free money and I get to walk away from this. And maybe I can portray it as a resignation. Maybe that would be better for me, right? But if I choose not to do that, then I'm going to stay here and I have these horrible performance issues and I'm not going to succeed at the company if I stay, right? So it's like not really a choice. They're really firing you. But it's the same thing. If you have a company or an insurance company, your employer offering money and asking you to sign away your legal claims, that should hopefully tee off for people an idea that they want to resolve this case with you because they know you have legal claims, right? Which should hopefully prompt you to talk to a lawyer because it probably means there's a lot more that you could be getting and that you should be aware of before you sign away your rights.
Yeah.
So what do you think people need to do aside from talking to a lawyer right away, is there anything else that people can do to maximize or make sure that they're not undervaluing their own case at the beginning?
I don't talk to insurance companies. And I hate to say that, but they will reach out. They want a recorded statement. They want all this information. They want you to sign a medical waiver, giving them unconditional access to your medical records. They are not benevolent actors. They are not doing that to help really understand the true value of your case. They are on a fishing expedition before you've hired counsel to unearth bad facts, prior medical history, anything that they can to try and reduce the value on your case. 10 out of 10, 100% of the time, that's what they're doing. They're taking recorded statements. I've listened to the recording statements. They're not just like really inquisitive questions. Tell me how the accident happened. They want to know your speed and where were you looking and were you distracted? And they start peppering in all these questions to try and unearth bad facts. Mm-hmm. And so, I always tell people don't give a recorded statement. Now, again, every factual situation is different. Talk to a lawyer, make sure that's the case. In some situations, you have a duty to cooperate with your insurer. So like if I'm making a claim to my own insurance company, we're in a contractual relationship, I have to cooperate. So I may have to give a statement to them. So there are different, settings where it plays out differently. But on the whole, insurance companies that are reaching out to victims, trying to get information from them, are doing that to undermine and devalue the claim.
This is another employment law similarity. So I have a case. This is a case actually a while ago, but it is very common. It's a very, very common thing. Something will happen in an employment context, right, in your workplace, and it's messed up. Whatever it is, it's a sexual assault in the workplace, it's sexual harassment, it's some event, some big thing, and my client is in the center of it. And the company will hire an investigator, right? Or they'll have HR do an investigation. And a question I get a lot is, should I talk to HR? Should I talk to the workplace investigator? And what I tell people is there's a really common misconception that HR has your own interest in mind, but they don't. They care about the company. They're trying to protect the company from liability and risk. And that's really their whole purpose. Now, that's not to say a lot of HR departments are very warm and fuzzy, and they also want to support employees, and they recruit employees, and they want to make sure that all the workers are as happy as they can be, and they have a good culture and all of that stuff. But when the rubber hits the road, if there is something that will cause the company risk that happens, HR's job is to paper the record in a way that will support their view of any case, of any litigation, their position, right? So, and I don't counsel people against talking to HR, but it has to be taken with that in mind, that your job, if you're talking to HR, is to be absolutely truthful. I mean, that should be your job anyway, all the time, but make sure that you're being very factual and truthful. And I always tell people, if it's possible, to ask for permission to record whatever conversations you have, because if you record without consent of the other party, we can't use that in the case. So that's not useful for us.
Not only can you not use it, it's a crime.
It is a crime. Yeah, there's a penal code section. Yes, absolutely. So I tell people, like, I don't want you recording anything. A lot of times clients will come to me and be like, I don't have to tell you what happened with HR. I have this recording and you can just listen to it. And I'm like, no, I can't. No, that is not helpful. But if you ask to record it, sometimes HR people will say, yeah, sure, go for it, and then at least we know what was told to them, what was told in the context of this investigation. But the bottom line is they don't have your best interest at heart. They're there to protect themselves. And so again, it is really fact specific, because sometimes I do think that bad workplace behavior can still be cured at the workplace level, right? Especially if my clients are still working there. So it's not like don't ever talk to HR. It's more just make sure you know what you're walking into and where all the players are.
Yeah.
Mm-hmm. What's next?
At-will employment. If you are an at-will employee, which most people are in California, can you be sued for anything? You're at will.
This is probably the biggest question I ever get. Always. Yes, California is an at-will employment state, which means your employer can fire you for any reason they want. They don't like the color of your shirt that day. They don't agree with a business decision you made. It's a personality conflict. They just don't get along with you. They can fire you, no problem. The way it becomes unlawful is when they fire you for an unlawful reason. Okay, what does that mean? It means if they're firing you because you're Black or you're pregnant or you're a woman, we call that because of your membership in a protected class. And California has a long list of protected classes. So it's not just gender and race and disability and pregnancy. It also covers things like reproductive rights. So reproductive decision-making is a protected class now. So if you decide to freeze your eggs, or you decide to get IVF, or you have an abortion, or, anything to do with your reproductive decision-making, if you're being discriminated against on that basis, that supports a discrimination claim. So it has to be targeted based on your membership in a protected class. And when it comes to or what we call protected activity, which is whistleblowing or opposing unlawful conduct in the workplace, you see something illegal and you call it out and you're like, I don't want to do that thing. And you get fired because of that. So the default mode is that it's an at-will employment state. You can be fired for any reason. But if the employer is firing you for one of those reasons, you're engaging in protected activity or because of your protected status, that's what makes it illegal.
Okay. So if you are someone and you think you've been terminated because you are a member of a protected class, how do you prove that? What are you looking for?
Yeah, great question. So it's very rare in this day and age for any direct evidence of racist or sexist intent or whatever the case may be. Like, in other words, someone's not going to write into an email, I fired so-and-so because they're a woman. That's just not what happens, because there's been enough litigation and enough public litigation for people to know that that's not a smart thing to do. I do still have cases where that's a thing, and it does still happen, but writ large, that's not the most common scenario. So we prove it through what's called circumstantial evidence. So what that means is I've spoken about this before. We look at relationships to events in time. So if someone, blows the whistle on Thursday and they're terminated on Friday, it's a ridiculous example, but those are the kinds of time relationships we look at in a whistleblowing case. When it comes to gender or race, we look at all kinds of conduct. So maybe there are comments that are made There was a case that I'm remembering where a Black woman was called unsophisticated multiple times. This was a case that actually one of our trial lawyer friends had, and she took it to trial, and had a very competent, very accomplished woman, a Black woman, trying to get a job as an attorney, and her white boss kept saying no to it because he called her unsophisticated, and she was obviously completely sophisticated. So sometimes there can be like very thinly veiled racist coded language like that that when you look at the panoply of conduct, you can really see that it's racially motivated. I've had situations where, gender can come up in the workplace where men are invited on to go to certain events or to speak with certain clients, and women aren't. I had a client where a Black client who was an executive at a really big, very well, refuted company, doing very well for himself. And he was assigned to a team in New Zealand to handle their software development. The team in New Zealand made a request to the employer that he not work on the case because he was Black. And it was a pretty direct, they didn't use those words directly, but it was clear based on other facts I won't get into that was the reason for that decision. And the company honored it and said, okay, we're going to take him off that account. And it was the biggest account, and it would have directly tied to his compensation. So, and then replaced him with a white worker, with a white employee who was super underqualified to do the same role. So these are the types of things like who is being given the opportunity if you are being denied the opportunity, and is it someone who's white or a man or whatever the protected status is? Those are the kinds of things that we look at. Stray comments is a big one. Being given certain job roles over other job roles. And then we also look at a lot of like racist and sexist tropes, like women being overly emotional, because a lot of times the employer will say, she just can't handle that because she's too emotional. Or an angrier Black woman I have a couple cases like that right now where they are portrayed as more angry, even though it's absolutely not factual and not even true at all and totally offensive. So those are the kinds of things we have to be a little bit, I don't want to say creative because we're not being creative about the facts, but be able to draw relationships to paint a picture of systemic discrimination, because that's what it is. It's not direct evidence. It's looking at all of a constellation of different pieces and putting it together in the picture.
That makes sense.
Mm-hmm. Okay, what about for you? What question do we have for Anjay today? What about insurance companies? Do they treat all clients the same? I've talked about some of the ways that my clients are not treated the same in the workplace. What do you see?
Exact same thing spills over into PI. Unfortunately, insurance companies pretty sure have an algorithm, some kind of AI software that's putting in baseline. Are you married? Are you single? Do you have children? Do you not have children? Are you white? Are you Hispanic? And then they essentially spit out a number. Your case is worth X. And I have seen on trend over the last decade plus that clients that are of minority status or are unmarried or don't have children tend to be undervalued. So I lose a leg, I have a spouse and a child. Insurance company says that my loss of a leg is worth more than a single person that's not married that doesn't have a kid. And I just find that offensive, obviously, because exactly. I see that with African-American clients. I see that with female clients. A lot of times, the attorneys that are hired by the insurance company will take a female client deposition, and they'll start asking really specific questions that I don't see them ask of my male clients about, well, you said your pain was a 7 out of 10. What are you equating that to? Can you try and describe that for us better? Just like second guessing their description of their experience. Again, falling into that women tend to exaggerate, women are hyperbolic, kind of that like systemic bias that we see.
Mm-hmm.
I had a trial recently where the defense attorney was asking a female physician on the stand who was explaining the level of pain that my client was experiencing from an injury. And he asked her, have you ever given birth? Very personal question. And the doctor, who was not the client, it was a doctor just testifying in the case, said, well, that's a really personal question. And he was allowed to ask it, so she answered. And the point that the attorney was trying to make to the jury, although I thought it was a little crass, was if you haven't had a child, then how can you understand what a 7 or an 8 pain level is?
What?
Exactly.
That's crazy.
But that's the kind of stuff that we see come up.
That's crazy because that would be like me being like, well, I've never broken my leg, but I'm a doctor, so I can't testify about anything to do with pain because about that person who's broken their leg. Like, it's her medical profession.
Exactly.
Why does she have to have experienced the actual pain to talk about pain?
Exactly.
Wowza.
Yeah. So I see that a lot by insurance companies. I see that by defense attorneys that are just kind of in this. Again, I think it's implicit bias where they've fallen into this cycle of women are overstating, people that don't have children don't have their claims not worth the same value because they're not needed on all these different levels. Clients that are from other countries. I've had some clients that were here on like work visas from Taiwan, from the Philippines, from Mexico. Insurance companies tend to undervalue those claims, and they will just make blatant statements in settlement talks about, well, they're going to take the US dollar settlement back to their country where the dollar goes further.
Mm-mm.
And that should not be part of the equation.
Mm-mm.
That should not factor in.
Mm-mm.
But it does. And it's really offensive. And it's my job to kind of shield against that and do my best to protect that dialogue and push back, tell the jury why that's offensive if we're at that level. But yeah, it's really sad.
Yeah. I mean, I think one thing, if we're talking about kind of trends in the law that I notice with my cases is that there are unfortunately, right, there are certain groups that end up being marginalized, I think, in our society. And like this was something noticed, I think, a lot during COVID, where certain people that work in certain professions really got hit hard by COVID, right? And so the pandemic was this like thing that affected all of us. But if you were already living paycheck to paycheck or like a little bit, or working in a really labor intensive job, the pandemic, or living in a home with a bunch of people in it, the pandemic like really affected certain groups of people over others. And I feel like the workplace is a little bit of a microcosm of the dynamics that we see kind of in broader society, meaning like there's just a lot of workers that really get taken advantage of. And because they don't have the financial like parachute, to fall back on, I think there are a lot of companies that kind of know that and know that they can underpay workers or not pay them overtime. And I've also represented undocumented folks and immigrants, and they don't know what their rights are. And they feel, frankly, a little bit timid or scared to even talk to a lawyer or even contemplate going to court for a variety of reasons related to their immigration status or they're just the lack of knowledge of what the law provides, right? So you have these employers that are really taking advantage and like preying on that vulnerability. And I just hate it. It really drives me crazy. And that's one of the reasons we're doing this podcast too, is I think that everyone should know what their rights are, right? At the end of the day. And then they can make their own decisions about what to do with that, whether it's nothing or something. But at a basic level, like you got to know what the law stands for and how the law protects you so that you can like make the best decisions for you and your family.
Yeah. There's been some great case authority in the last 5 years for undocumented plaintiffs that immigration status is not admissible in a civil case, which has been huge. So there isn't a fear that if you are undocumented, you can't come forward and make a wage claim or an emotional distress claim or something against a wrongdoer. And I don't know if that is also true in an employment setting or if that can be more complicated in an employment setting.
It can be a little bit more complicated. And so just to break down what you said so that to like really simplify it, when we say inadmissible, what we mean is if we are to present a case to a jury, there's certain evidence that can be shown to the jury and certain evidence that cannot. And if we're saying it's inadmissible, it means undocumented status, whether you have immigration status, is like irrelevant and not thought of in the legal case. So you can bring it forward and keep that part of your life a secret, and it doesn't have to be litigated in the case. The company defendant on the other side doesn't have to know about it. It's not a part of the case. So just wanted to kind of clear that up. Yeah, in the employment case, it's a little different because, and I won't go too much into the weeds, but it really depends on whether the employer knew that the employee was undocumented when they hired them. If the employer knew from the get-go that they were undocumented, then for sure I would think that it would be inadmissible. There's some differences though around whether the employee was lying about that. And that can come back to bite the employee under this legal doctrine that I won't get into right now. But that's one distinction. And the law is honestly constantly developing in this area on the employment side because of the different nuances around undocumented folks. And anyway, it's a whole ball of wax. And our immigration laws are constantly changing, and the deportation orders that are happening are constantly evolving and creating a lot of fear, I think, with a lot of undocumented folks as well. So that obviously plays into people's thinking about it.
Yeah. Okay, let's talk about another rumor that comes up frequently, and that's waivers.
Yes.
So this can come up in the context of you're on a work conference weekend, you've signed a waiver related to the trip, maybe something goes wrong, there's an event, somebody got hurt, somebody got harassed, comes up like you buy a lift ticket, you go to a ski resort, you're injured, your lift ticket had a waiver. So let's just generally talk like if someone signed a waiver in some capacity, does that mean they're screwed? There's no case.
Yeah, great question. This comes up way more in personal injury than it does in employment. The biggest thing so what we're talking about with a waiver too is usually a contract, usually a document. Sometimes if you're going on a ski trip, it's like the teeny tiny print that's pasted right on that like big zipper flap that you have, maybe. It can be anywhere really, but it's with like recreational activities. The waivers that come up in the employment context are usually releasing your legal claims. And usually that happens when you're fired at the end, which is what we already kind of talked about with signing away things. But you do also sign documents when you start work. And the waiver of the jury trial is the biggest, most important thing that employees sign at the very beginning of the case, of their employment without knowing it. And what that usually it's titled arbitration provision, and it means that you're signing away your constitutional right to a jury if something arises in your employment that you need to sue your employer for later. And it means you don't get a jury, you get limited discovery, your case is tried and adjudicated by usually a retired judge. And importantly, the retired judge who decides your case is being paid by your company. So it creates this, in my view, sort of an potentially unequal playing field at least, and is giving away your constitutional right. And most people, when they start a job, don't want to negotiate the first term. They don't want the first interaction with their employer to be negotiating this term of the agreement that they barely even know what it means, and no one expects to sue their employer. So yeah, that's the biggest thing that I see that really troubles me in the employment case when it comes to waivers. But
you know what I've seen recently that I think is really important for viewers to hear? Some companies in different settings, like I have some elder abuse nursing home cases, they will have an arbitration clause in the agreement, which we're seeing now is pretty standard across the board, but it will have an opt-out provision. And really they're doing this to try and say, I gave you plaintiff, injured person, the option to opt out, and you didn't do it. And so we really are in arbitration and should stay in arbitration. And it wasn't unfair because I gave you 7 days to put in writing back to me that you're opting out of arbitration. So as much as, a lot of the boilerplate contracts, credit card contracts, Disneyland tickets, all of that, you quote unquote can't negotiate. I have seen some really kind of coy companies lately putting in opt-out clauses. So as annoying as it is to like read the fine print on things like a nursing home contract, a landlord-tenant lease, I would suggest read the fine print, especially if you can hone in, do a, Control F, look for an arbitration clause. And if there is an opt-out provision, I recommend everybody opt out.
Yep.
You're going to have a much better faring in a civil jury trial than you are before, like you said, a corporate arbitration.
100%. Totally agree. Yeah. How do waivers work? So I went to Ski Mountain and I signed a bunch of documents to get there. And I'm like Gwyneth Paltrow, and I broke my body on a ski. I don't actually know what happened with Gwyneth, but I just read some headlines. Yeah. So what happens? Have I signed my rights away? Do I ever get to bring a legal claim? Am I out of luck?
So I think it's always worth talking to a lawyer in a waiver setting because waiver law is so nuanced and it's fact driven. So generally speaking, if you've signed a waiver, you've waived your rights if you're injured, and it's a risk inherent in the activity. So if you're skiing and you hit a tree and it was like just a normal tree that was right off the course and there was nothing that the course like created a path that led you right into the tree or something, so they didn't increase the risk, it's just an inherent risk in skiing, no case. If it's a scenario where the mountain was designed in a certain way that led you or entrapped you into a hazard and so the risk of skiing has been increased, then that may fall outside of the waiver. So again, it's very nuanced, down a rabbit hole. But if you've been seriously injured, even if you think you've signed a waiver, it's worth having an attorney look at.
Yeah,
for sure.
I mean, I think that's just true in general, right? Like, I just can't imagine having a serious injury, having there be a wrongdoer out there that really it should be them paying your medical bills and not you, and not pursuing that. Like, I think serious injury, call a lawyer should be the thing, just to know what your rights are.
Yeah, agreed.
Mm-hmm. What else?
What are some other rumors?
I think there's a big rumor that you can sue your employer for any mistreatment in the workplace. And this is one that I get most frequently with what I'll call toxic workplaces. So a workplace where you come to work and you are bullied by your boss or by your coworkers, you're put down, your work is minimized, you're made to feel like complete trash. And a lot of people call me and they're like, let me tell you all the ways that my boss is a big jerk to me. And I've said so many times, it's not illegal in California for your boss to be a jerk, unfortunately. The only time a harassment claim like that becomes illegal is if it's targeted on the basis of your membership in a protected class. So it has to be targeted against you as a woman, or against you as a person of color, or your disability, or your pregnancy, or what have you. And that is, I think, the biggest misconception. There are a lot of toxic workplaces out there, and this sounds like a very elitist thing to say, but the best thing you can probably do is to try and find another job if you're in a situation like that. It's not to bring a legal claim. But if you are the victim of something because of your membership in a protected class, or you see someone else being victimized on that basis, that could also form a harassment claim. And just to be clear, there's two different kinds of harassment. There's what I just described, which is hostile work environment. But then there's also something called quid pro quo, which is the classic like boss who says to his secretary, have sex with me or I'll fire you. She says no, and then she gets fired. That's a little bit less common, although I do have a few cases like that, and it absolutely still happens. So it's like hinging sexual favors on work performance or work punishment is basically how that one works.
Makes sense.
Yeah.
Okay. Well, that's episode 3.
Great.
Rumors, hopefully debunked. And if anyone has any questions or legal rumors that they think are worthy of airtime, drop them in the comments and we'll answer them on future episodes.